Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video, and I'm very excited today to have with us Attorney Nicole Reeves Lavallee. She owns a family law firm out of Worcester. She is fantastic, knowledgeable, really up in all the latest strategies on how to get the best outcome in court. Today, we're going to be talking about contempt. Now, Nicole, welcome to the show.
Thank you.
You're welcome. And you know what I'm going to say? Most people think of the word contempt and divorce and they think, oh, yeah, well, you know what? That makes a lot of sense. That's a good word to go with the topic of divorce. So, besides the contempt that you might feel for your significant other or soon to be ex significant other, can you tell us what is contempt when it comes to a court case?
Contempt is an action where there is an order. There's an order from the court and somebody is not following it. So it is a remedy available to you, and the complaint is called a complaint for contempt, which will address what that person is doing and why they are doing it wrong or in violation of the court order. So that's basically just the legal term that allows you a remedy to resolve that issue.
So, with that definition in mind, who can actually file for contempt?
Anyone who has been in an action. So whether you're the plaintiff or the defendant, if there is a court order, it could be a temporary court order, it could be a final judgment, it could be a further temporary order. So if there's an order and if you're a named party, plaintiff or defendant, you can file a complaint for contempt based off that court order itself.
Well, a lot of times we talk about how long do things take, because we know with court, things get dragged on sometimes. So in this case, when you're filing contempt, how long can you typically expect it to take to get that into court?
The general rule is you're going to be looking at about a month's time. So from the date that you file it to the date that you actually go into court and have the judge rule on it is going to be at about a month. Now, that being said, because of COVID, obviously that's going to be a little bit different and there's a little more restrictions on it. So right now you're probably looking at about 2 to 3 months for contempt, but generally the average is a month. There are certain circumstances, very, very limited, that we can get in about 8 days.
Okay, so yeah, and I know everything has been kind of spread out and the process is a lot different now, where you don't actually have to go to court all the time. A lot of things are being done over Zoom and teleconference. What happens in the hearing typically?
Again, depends on what kind of hearing we're going to have. Sometimes contempts are also still going to be going in front of dispute intervention, which is probation department. So if it's going there, you may have 2 hearings. Obviously, if we're in the courthouse itself, it will be the probation office in the morning and then the court as soon as we're done with it. So might be 2 hearings, might be 1, depending on where we are with the court system itself. But basically we make our pitch to both the probation department and or to the court. If we resolve it in probation, then generally the judge will just look at it and rubber stamp it and say it's okay. If we cannot resolve it in probation and dispute intervention, then we would go in front of the judge and the judge would hear arguments. Now, that's the general rule. Is a party entitled to an evidentiary hearing? Yes. So an evidentiary hearing is a trial. It is exactly what a trial is about. That will never be on the same day. So if you want immediate gratification, you're going to resolve it or you're going to let the judge resolve it that day. If you want your day in court to kind of expand and give your version of events, which normally is going to be done by the attorneys, then at that point in time, you'll have another hearing at a later date where we will submit exhibits and testimony will be given, and then the judge would make a ruling. But those could be 6 to 9 months out.
So can you actually be found in contempt?
Absolutely. The judge at the end of it will be making a determination as to whether or not you are in contempt or not guilty of contempt. If you're not guilty of contempt, then it's just follow these new orders or follow the previous orders. If you are guilty of contempt, then there can be ramifications for that.
So the ramifications are really on top of whatever else you're in court for.
Correct. So the ramifications can be severe. I mean, it can be something that, you're going to be responsible for your ex's attorney's fees, which nobody wants to pay. They don't even want to pay their own attorneys, let alone somebody else's attorneys, especially somebody they don't like. They could be sanctioned, where they have to pay the court money. Or worst case scenario for them is they could be held in contempt and be locked up. So they can physically go to jail. And usually if that's the case, then there is what is called a purge amount. So that's usually a financial issue. Not only have you done something really bad, but as a result of it, we're going to lock you up until you give us X amount of dollars, and then we'll release you.
So, I mean, you hear things in the movies, and it's usually, oh, you're going to be in contempt, and then usually somebody's getting thrown out of court because they had an outburst or something. And then I know that in the past we've talked about being in contempt for not handing over files and personal information that you're supposed to hand over to the other side of whoever you're in court with. I mean, what are some of the other common reasons, or if you want to say what I just said better, what are some of the reasons for being found in contempt?
Well, and you're right. Generally, when you have that outburst in court, and that's usually dramatized on TV, but when you have that outburst in court, generally the court will give you one slap on the wrist, like, stop it. That is not a complaint for contempt. So I think there's two different issues, but a contempt of court can be done when the court says you are completely unruly, you are acting unprofessional, and we will not tolerate this behavior. And that would basically mean go to lockup. And usually that's go to lockup and think about what you did, and I'll release you at the end of the day. Or I'll release you when you produce something. That is discretionary to the court. That is in all of the courts. So that is not just probate court. That is district court, superior court, potentially housing court, although I've never seen it there. So it can be happening throughout any of the courts. The judges do have that power. Obviously, from my perspective, a complaint for contempt is going to be based on anything. So it can be you were ordered to pay health insurance and you stopped paying it. You stopped paying alimony, you stopped paying child support, you refused to return the child, you refused to pay for extracurricular activities. So it really is kind of the gamut. It could be that we had an agreement that you're supposed to sell the house and you refused to hire any brokers, or you refuse to acknowledge something. So again, it goes back to what does that court document say, and why aren't you following it? Because if you're not following it, then there's going to be the ramifications. So we really got to look at what that document says. And obviously in a divorce situation, you're going to deal with division of assets, division of liabilities, health insurance, alimony, and all child related issues. So if any one of those you're not following, you could be held in contempt of court.
So what does that do to your pending case if you are found guilty? I mean, it can't make you look good, and I would imagine it doesn't make your results come out the best. So what have you found?
It definitely doesn't help. I mean, obviously there can be a contempt after judgment. So if you already divorced and there's no pending modification, it might not have that much of an impact because it's kind of a one and done hearing and there's nothing before the court other than this action. But if you later file a modification, the judge is going to look at that and go, oh, this is a previous contempt. Let me figure out what I need to do with it. And that's exactly what they're going to address. So if you do have a pending case and say, for example, you're fighting for custody, yet there's a complaint for contempt where the judge found that on 3 or more occasions, you refused to return the child, well, what's going to make that judge say, yes, you're a good parent and you're doing something that's in the best interest of the child? So that's going to have a direct impact on their ultimate outcome of that case. So you really got to take into consideration settling the case immediately rather than going in front of a judge, rather than getting a complaint for contempt against you, and trying to act like an adult, because if not, the ramifications may be that you lose your child. It could be that you lose financial money. It could be a lot of things that are all going to be to your detriment.
Well, I mean, it's good that you, honestly, I think that it's good that you still have the court behind you to help enforce things, because things do change in people's lives, and sometimes people feel entitled and they decide that they just don't want to do what the court had awarded the other person, or vice versa. Maybe somebody's decided they want to move and they didn't go through the proper channels, and you have a child together, so it's a really big deal. And so it's nice to know that even though it might take some time, you're able to go back and say, hey, by the way, this person is straying, because we all know those people that they take a little more and they take a little more, and then pretty soon the original agreement, what's happening now looks nothing like the original agreement. And I mean, how often do you see that happen?
A lot. And it's one of those things that, again, a prime example was I have somebody that, was going through a financial struggle. Alimony was $1,000 a month, was paying it faithfully for 2 years, then went into financial struggle and said, hey, can I do $700? And the answer was no, but I want to work with you. I'll give you time to repay the additional money. Let's continue to move forward. And then it was, oh, I'm just going to randomly reduce it down to 500. And no communication. And at some point, you're going, hello, that's unacceptable. We can't have that. And so those are the people that are really moving forward and going, this isn't agreeable to me. So you do have that remedy to go, hey, I never approved it. And even if I did approve it, I can always go back to the court order, because the court order is going to dictate not whatever agreement we may or may not have reached in the meantime. So it really does have some teeth that, again, people should work together when is necessary, but people should not be taking advantage. And that's the great thing about the contempt, is because, again, you can get in there quickly and you can get those issues resolved. And guess what? When you start having to pay attorney's fees for somebody else's actions, that's going to have a consequence that people remember.
Well, I really want to thank you so much for shedding some light on this, because I know people think, hey, I got through the divorce, or I got through this family court matter, and now we've got everything figured out. And more often than not, unfortunately, a couple of years down, sometimes things end up changing. Somebody might get remarried, and they might decide that their new life is more important than their current, what they had to do for the other one. I mean, there's a lot of things that can happen. So it's good to know. And I would love to tell everybody out there that if you do have any questions on contempt, on alimony, divorce, child support, and anything like that, anything that has to do with the family, if things don't seem to be going right and you need some advice, pick up the phone and call the office of Nicole Reeves Lavallee, because they are just fantastic. They stay on top of all of the new laws. They are great with strategy, and they're really looking to get the best outcome for you. And, they always keep, if kids are involved, they always keep, the children in mind, making sure that the children are really taken care of. And so, definitely give them a call. Thank you so much, Nicole, again, coming on here during a snow day. It's really great of you.
It was great coming on, and hopefully you learned something new today.
We always do. All right. Thank you so much. We'll see you later.